Well, welcome everybody to Tar Heel Tea Party. I have a couple of flyers up here I'd like you to take. One is on the Gadsden license plate that the Tar Heel Tea Party is trying to get through. We need 500 sales by March 27th to get it done this year. And if not, we'll hold it over until next year and try to get it done by then. There's some bumper stickers up here. And then there's a little notice sheet here about convention states that the committee is in the Judicial 1 committee right now, and it's got the committee members' names and so on the sheet for you to contact and tell them what you think about the convention of states and why North Carolina should or shouldn't participate in it. And short and sweet, and I give you Publius Huldah.
Thanks very much. Thanks for coming. We are in grave danger of losing our Constitution. Alexander Hamilton said that of those men who overturned the liberties of republics, most began by paying obsequious court to the people, commencing demagogues and ending tyrants. Federalist Number 1, 5th paragraph. That is going on today. We are being duped by false friends demanding a convention where they claim they can improve this Constitution by amendments, while they actually scheme to increase government power over us by rewriting our Constitution. In addition, George Soros, Marxist law professors all over the country, Cass Sunstein and Eric Holder, are also pushing for a convention so they can impose a Marxist constitution on us by the year 2020. Before these change agents can get a new constitution, they need a convention, because a new constitution can only be introduced at a convention. Some well-meaning patriots and respected political figures have made a mistake in suggesting that through the holding of an Article 5 convention, there is assurance that we can rein in the feds and make them cut spending. But there is no such assurance. I will show you. Let's begin by looking at Article 5 of our Constitution. It provides two methods of amending our Constitution. Congress proposes amendments or calls a convention to propose amendments if 34 states apply for it. The first method was used for our existing 27 amendments. Congress proposed them all. We have, under the second method, Congress calls the convention. We have never had a convention under Article 5 for good reason, as you will see. Let's look at the 5,000-year miracle we will lose if there is a convention. When we ratified this Constitution, we created the federal government. It is a federation of sovereign states united under a national government for those limited purposes itemized in the Constitution, with all other powers reserved by the states or the people. In this Constitution, we listed every power we delegated to our creature, the federal government. The Constitution is short because the list of delegated powers is short. Most of the powers delegated to the federal government over the country at large are listed at Article 1, Section 8, Clauses 1 through 16 on this one little page. All our Constitution authorizes the feds to do for the country at large falls into four categories. 1, military defense, international commerce and relations. 2, immigration and naturalization. 3, domestically create a uniform commercial system, weights and measures, patents and copyrights, money system based on gold and silver, bankruptcy laws, mail delivery and some road building, and with some of the amendments, secure certain civil rights. That's basically it. All other powers are reserved to the states or the people. This one-page chart, and I've got one for you to take home, illustrates two principles in our Declaration of Independence and how those principles were implemented in our Constitution, that our rights come from God, and the purpose of civil government is to secure the rights God gave us. Most of the enumerated powers delegated to the federal government are listed on this column. In 1776, with our Declaration of Independence, we lit such a beacon as the world had never seen. And in 1787, our framers gave us a constitution with a federal government whose sole purpose was to secure our God-given rights to life, liberty, and property by means of exercising the handful of enumerated powers. And when a government merely secures God-given rights, we are never put in conflict with each other because no one has his hand in anybody else's pocket. It is only with respect to the enumerated powers listed in the Constitution that the federal government has lawful authority. If it's on the list, Congress may make laws about it. But if it's not on the list, Congress acts unlawfully and usurps power when it interferes. Depending on how you count, Congress only has 18 to 21 powers over the country at large. If we followed our Constitution, most people could live their entire lives without having anything to do with the federal government. So why is our country becoming a totalitarian dictatorship? Because for 100 years, the federal and state governments have ignored our Constitution. Our Constitution is not the problem. Ignoring it is the problem. It was our duty to enforce our Constitution and make our public servants obey it. But long ago, we stopped reading our Declaration and Constitution, and because we didn't know what they say, we were unable to do our duty to vet, monitor, and discipline our public servants. We allowed our servants to bribe us into surrendering our liberties. That was the purpose of the unconstitutional government assistance programs of the early 1900s, Social Security in the 1930s, Medicare in the 1960s, to demoralize us, strip us of personal responsibility, and make us dependents, so that we would dance to the tune of our servants instead of making them dance to ours. Our tune is the liberty enshrined in our Declaration of Independence and Constitution. The federal government has ignored our Constitution for 100 years. It has usurped thousands of powers which are not on the list. State governments have collaborated with the usurpations, and we, the people who ordained and established it, don't have a clue what it says about anything. We don't know that Congress has lawful authority only over the 18 to 21 powers listed, enumerated in the Constitution and on the chart you'll get. We have believed the monstrous lie that the federal government can do whatever they want, except as limited by amendments. False friends have exploited that ignorance when they tell us amendments can limit the powers of the federal government. But when people learn this short list of enumerated powers, they can't be deceived by false friends who tell them the remedy for a federal government which has seized thousands of powers not on the list is to change the Constitution. When the federal government seizes powers which aren't on the list, what part of our Constitution do you amend to fix it? Do we need an amendment saying the feds can't do things which aren't on the list? We already did that. It's the 10th Amendment. They ignore the 10th Amendment. Even so, Mark Levin and Michael Ferris and Rob Nadelson of the so-called Convention of States Project insist the problem is the Constitution. They say the solution is change the Constitution. Yes, even though the federal government abandoned the Constitution 100 years ago and ever since does whatever they want, all we need to do is change the Constitution and that will fix everything. Levin and Ferris say amendments will limit the power and jurisdiction of the federal government. But our Constitution already limits the powers of the federal government to the 18 to 21 powers on this list. So how can changing our Constitution limit the powers of the feds when they are already doing thousands of things our Constitution already says they can't do? Look at guns. Our Constitution doesn't delegate to the federal government power to regulate guns, gun sales, ammunition, firearms dealers, and do background checks, but they do it anyway. So let's get an amendment saying they can't do any of that. But we did. It's the 2nd Amendment. They ignore it. So the claim of these false friends that we can control the feds who ignore the Constitution by changing the Constitution is so absurd they cannot possibly believe it. They have a hidden agenda in agitating for a convention, and from the absurdity of this claim and their additional false claims, we may infer evil intent. We know that Mark Levin and Michael Ferris don't want to limit the power and jurisdiction of the federal government because the amendments they have proposed delegate new powers to the federal government or legalize powers the feds have already usurped. Let's look at just 4 of their amendments. Michael Ferris is pushing a parental rights amendment he says would protect parental rights. But it does the opposite. It expressly delegates power over children to the federal and state governments. Here is his amendment. You can see all of my exhibits after. I wrote 2 papers on Ferris's parental rights amendment. They're online. Ferris's amendment repudiates our founding principles that rights come from God and are unalienable, and that the purpose of government is to secure the rights God gave us, and adopts the UN New World Order theory that rights come from the government, will be determined by the government, and are revocable at the will of the government. His parental rights amendment says at Section 3 that neither the United States nor any state shall infringe these parental rights without demonstrating that its governmental interest as applied to the person is of the highest order and not otherwise served. Mark Levin's amendments also do the opposite of what he claims. My paper, Mark Levin's Liberty Amendments Legalizing Tyranny, it's online, shows how 6 of his amendments legalize powers the feds have already usurped. Levin's amendment to limit the federal bureaucracy legalizes what are now unconstitutional federal agencies: education, energy, agriculture, EPA, DHS, HUD, HHS, etc., etc., etc. Our Constitution doesn't authorize these agencies. They're not on the list. But Levin's amendment legalizes them. Article 1, Section 1 of our Constitution says only Congress may make laws. But since Woodrow Wilson, federal agencies have been writing rules. This is the abominable code of federal regulations. All these rules are unconstitutional as outside the scope of powers delegated and is in violation of Article 1, Section 1. But Levin's amendment to limit the federal bureaucracy legalizes these rules and the rulemaking process. Levin's amendment to limit federal spending is also phony. Our Constitution limits Congress's spending to the enumerated powers. If you go through the Constitution and highlight all the powers delegated to Congress and to the President, you will have a complete list of the objects on which Congress is authorized to spend money. That is how our Constitution controls spending. But everybody ignores it. Levin's amendment substitutes a budget for the enumerated powers and thus legalizes the current practice where Congress spends money on whatever Congress or the President put in the budget. And while it pretends to limit spending to revenues, it actually permits Congress to suspend the spending limit and continue to raise the national debt. Levin's amendment to protect private property is a major step towards eliminating private property. Our Constitution restricts the lands the federal government may own to the enumerated powers. But Levin's amendment permits the federal government to own property for any use they deem a public use. It legalizes takings by regulation by all levels of government, county, state, and federal, and provides that as long as the taking does not reduce the value of the property by more than $10,000, the governments don't have to pay the property owner 1 cent. You must read proposed amendments and understand how they change the Constitution before you support them. Don't go by the names of the amendments, and for God's sakes, don't go by what they say the amendment will do. The names of their amendments are chosen to deceive you. Read this paper, Mark Levin's Liberty Amendments Legalizing Tyranny. Levin's, it's online, and Levin's other amendments are just as treacherous. These False friends are deceptive when they say they want amendments to limit the federal government or limit federal spending. Their amendments institutionalize the very abuses they purport to correct, nullify the natural rights of the people, and fundamentally change the constitutional design. Even though our Constitution is not being enforced, it still declares this federal government lawless. The rule of law is still on our side, but not for long if we foolishly allow our Constitution to be replaced. A bill has been introduced into this session of the North Carolina Legislature, H.J.R. 48, sponsored by Representatives Jones, Millis, Riddell, and Pendleton. The bill chants the COS mantra that we need an Article 5 convention to propose amendments to limit the power and jurisdiction of the federal government and impose fiscal restraints on the federal government. It also says we need term limits, but the problem isn't how long people serve in Congress. The problem is everybody in Congress ignores the Constitution. But once people understand that our Constitution already limits the federal government to the 18 to 21 powers on the list, and our Constitution already limits Congress's spending to the enumerated powers, they can see how idiotic it is to claim that the remedy for a federal government which ignores the Constitution is to change the Constitution. Their claim is so idiotic, you know they have something up their sleeve. This year, warriors in Virginia, Ferris's home state, and Indiana have stopped their legislatures from passing applications for a convention. Lots of lobbying, emails, phone calls, and personal visits. This topic, as you know, is hot right now in North Carolina. You might defeat it. We defeated it in Ferris's home state. So fight. Don't give up. False friends say, we must amend the Constitution because people in Washington don't understand it. Rubbish. Our Constitution is so simple that Alexander Hamilton said, the people are the natural guardians of the Constitution. Federalist Number 16, next to the last paragraph. For clauses the Supreme Court perverted, Interstate Commerce Clause, General Welfare Clause, Necessary and Proper Clause, a quick look in the Federalist Papers shows the original intent of these clauses. We don't need a convention to draft amendments showing what these clauses mean. Just look it up in the Federalist Papers. But I have already done it. It's all in this one sheet of paper, the original intent of those three clauses as proven by the Federalist Papers, and you can have a copy. For 50 years, change agents have tried to get an Article 5 convention. We stopped them. So false friends repackaged the push for a convention. They now market it as an issue of states' rights versus the federal government. They say we must amend the Constitution to restore powers the feds have taken from the states. Rubbish. The 10th Amendment says all powers not delegated to the federal government by the Constitution are reserved to the states or the people. What happened to those reserved powers? The states sold them to the federal government. God gave parents the duty to educate their children, but parents let state governments assume this duty. So today, states are forcing children into federal education schemes such as Common Core. They did it for the federal grant money. DHS is nationalizing local and state law enforcement. DHS answers to Obama. In Tennessee, DHS is involved in issuing driver's licenses. In 2004, the Tennessee legislature passed an act putting the county sheriffs under the control of DHS. Learn about the fusion centers in every state. The states went along with it. Thanks to state governments, Obama is getting a national police force like the East German Stasi, and we are losing local control over law enforcement. According to the Pew Report, federal funds make up an average of 1/3 of the state's annual revenues. About 33% of North Carolina's revenue is from federal funds. The states don't want to cut federal spending. They don't want to lose their federal funds. Last session in Tennessee, a Tennessee legislator introduced an Obamacare nullification bill. But the fiscal note said that if her bill passed, Tennessee would lose $6 billion in federal funds. Well, those Tennessee state legislators didn't want to lose all that federal money. So Tennessee is not going to nullify Obamacare. Meanwhile, those same Tennessee state legislators preen their moral outrage over out-of-control federal spending. State governments are not victims of federal tyranny. They are enthusiastic participants in federal tyranny. False friends fabricated the preposterous claim that our framers said the purpose of amendments is to rein in the feds if they usurp power. Our framers never said that when the feds ignore the Constitution, our remedy is to change the Constitution. One delegate at the convention of 1787, George Mason, objected to Congress controlling the amendment process. So on the last day of deliberation, September the 15th, 1787, the convention method of proposing amendments was added. But since Congress calls the convention, and because of the necessary and proper clause at Article 1, Section 8, last clause, Congress has exclusive authority to organize the convention. So George Mason didn't get his way and was one of only 3 delegates at the convention who refused to sign the Constitution. James Madison writes in his journal entry for September the 17th, 1787, quote, "The Constitution being signed by all the members except Mr. Randolph, Mr. Mason, and Mr. Gerry, who declined giving it the sanction of their names, the convention dissolved." Signed, James Madison. Yet false friends claim that George Mason, one of the 3 dissenters, is the one who called the shots. We must distinguish between defects in a constitution and a government's refusal to obey the Constitution to which it is subject. There were defects in our Constitution, slavery, amendments fix defects. But our problem is a disobedient federal government and disobedient state governments. That calls for different remedies, and our framers spelled them out. What our framers who signed the Constitution actually said is amendments remedy defects in the Constitution. That amendment of errors and useful alterations would be suggested by experience, and that useful amendments would address the organization of the government, not the mass of its powers. False friends say that at the convention, the states will appoint the delegates, control the delegates by means of state laws. Each state will get one vote at the convention, and Congress has no power over the convention. The states run the whole show. And they say they know this because former law professor Rob Natelson says these were the customs followed in conventions during our founding era. They say Congress will follow these same customs if Congress calls a convention under Article 5. But we have never had a convention under Article 5, so Natelson's customs are irrelevant. Furthermore, there is no such thing as a convention of states to propose amendments. At a speech Natelson gave on September the 16th, 2010, he announced that he would stop calling what he wanted a constitutional convention. Henceforth, he would call it, among other things, a convention of states. Here is his speech. He makes this announcement of the new term at the top of the second page of his speech. The new term is a marketing gimmick to make people believe that there is such a thing as a convention controlled by states to propose amendments to our Constitution. But the truth is, the states have no power whatsoever over the convention provided at Article 5. All they can do is ask Congress to call a convention. Congress calls the convention. A call is the official summons for the convention to take place. It states the date and location, how delegates will be appointed, and so forth. Furthermore, Article 1, Section 8, last clause, delegates to Congress the power to make all laws necessary and proper to carry out its power to call the convention. Congress gets its legal research from the Congressional Research Service, the CRS. Here is their April 2014 report on issues under an Article 5 convention. CRS confirms that Article 5 delegates to Congress exclusive authority over both methods of amendment. The report shows that in Congress's preliminary preparations for Article 5 conventions in the past, Congress has provided that delegates to an Article 5 convention would receive immunity from arrest, as in Article 1, Section 6, and has planned to apportion delegates the same as in the Electoral College. So California would get 55 delegates, North Carolina would get 15. So if Congress permits the states to select delegates to a convention, Congress decides whether each state will get one vote or whether the state's electoral votes will determine how many votes they get. Congress may decide to appoint themselves as delegates. Nothing requires Congress to permit states to select delegates. And Congress has the power to grant delegates immunity from prosecution. False friends insist they know exactly how a convention will operate, but page 27 of the CRS report says, quote, "In the final analysis, the question, what sort of convention, is not likely to be resolved unless or until the 34-state threshold has been crossed and a convention assembles." See, the CRS says we'll have to get a convention before we know how it's going to operate.
Does that sound familiar?
Mm-hmm. False friends say a convention is safe because 3/4 of the states have to ratify whatever comes out. That is a lie. Listen, your life depends on it. If another convention is called, the delegates are invested with that inherent sovereign right of a people to alter or abolish their form of government. Declaration of Independence, second paragraph. We've already abolished one constitution and replaced it with another. After July the 4th, 1776, we operated under our first Constitution, the Articles of Confederation. That was our Constitution until this one was ratified in 1788. This is our second Constitution. How did we get from our first Constitution to our second Constitution? There was a convention to amend our first Constitution. Pursuant to Article 13 of the Articles of Confederation, the Continental Congress resolved on February the 21st, 1787, to call a convention to be held at Philadelphia, quote, for the sole and express purpose of revising the Articles of Confederation, end quote. But the delegates ignored this limitation. They also ignored the instructions from their states and wrote our second Constitution. Because of the inherent sovereign authority of delegates, it is impossible to stop it from happening at another convention. If we have a convention now, George Washington, James Madison, Benjamin Franklin, and Alexander Hamilton won't be there to protect you. You don't know who the delegates will be. And you won't find out until it's too late. But they will have the power to impose a third constitution. A third constitution will have its own new mode of ratification. Whatever mode will ensure approval. Our first constitution, the Articles of Confederation, required all of the then 13 states to ratify amendments. But our second Constitution, drafted at the Amendments Convention of 1787, provides at Article 7 that it would require only 9 states for ratification. 13 states needed to ratify amendments to the Articles of Confederation, but only 9 states needed to ratify the new Constitution. If we have a convention today, there is nothing to stop delegates from proposing a third constitution with its own new method of ratification. New constitutions are already prepared and waiting for a convention. Here are 3. 50 years ago, the Ford and Rockefeller Foundations produced the Constitution for the new states of America. It is ratified by a referendum called by the president. The states don't vote on it. The states are dissolved and replaced by regional governments answerable to the new national government. Read the new state's constitution and tremble for your country. The Revolutionary Communist Party USA has a constitution, the Constitution for the new Socialist Republic in North America. And George Soros, the Marxist law professors all over the country, Cass Sunstein and Eric Holder, they are in 2020 movement funded by George Soros, and they want their Marxist constitution in place by the year 2020. False friends George Soros and Eric Holder have the same goal: a convention so they can get rid of this pesky constitution and impose a third constitution. Now, Michael Ferris might plan to write the third constitution, whereas the new states people say, no, we want the new states constitution, and George Soros will say, no, we want my constitution, and the Revolutionary Communist Party USA will say, no, we want my constitution. Which one will win? Well, who's got the money? George Soros has the money. He can buy the delegates to get the constitution he wants. So, whether Congress or the states set up and organize the convention is not the critical issue, because in either case, the delegates, whoever selects them, are vested with that inherent sovereign right to throw off this Constitution and propose a third Constitution with a new mode of ratification. That is why state laws can't control delegates to a convention. The delegates are the sovereign representatives of the people and can do whatever they want. And just as the delegates to the Convention of 1787 overthrew our first Constitution, delegates to a convention today can overthrow our second Constitution, and you won't like the third Constitution. Look behind the curtain false friends have put up. Progressives, Fabian socialists have been trying for 50 years to get a new constitution. That's why they have been pushing for an Article 5 convention, because the only way they can get rid of this constitution and replace it with their New World Order constitution is to have an Article 5 convention. Michael Ferris is not being truthful about the grave dangers. During April 2014 in Mechanicsville, Virginia, Ferris said in response to a question expressing concern about George Soros's and the AFL-CIO's desire for a convention, Michael Ferris said, quote, and I've got this on video, contact me and I'll give you the link to the video, plus a partial transcript. Ferris said, quote, George Soros can get an Article 5 convention when he gets 34 states to pass an application he likes. He can't come hijack my applications, end quote. Yeah. Article 5 doesn't permit factions to have and control their own conventions. There is only one convention, and Congress calls it. And remember, a new constitution has its own method of ratification. Whatever method ensures success. It can be majority vote in Congress, or signature of the president, or approval by 5 justices on the Supreme Court, or, as with the new state's constitution, a referendum called by the president. Think not that the third constitution will have the same method of ratification which our second one has at Article 7. So, what is needed before one of these 3 constitutions from hell or another one can be imposed on us? A convention. And that is the hidden agenda behind this push for a convention. A new constitution can only be introduced at a convention. Wise men have warned against an Article 5 convention. Here are 3. James Madison, father of our Constitution, wrote in his November 1788 letter to Tuberville that he trembled at the prospect of a second convention, and that if there were an Article 5 convention, the most violent partisans and individuals of insidious views would strive to be delegates and would have a dangerous opportunity of sapping the very foundation of the fabric of our country. In Federalist Paper number 49, Madison warned against an Article 5 convention to correct breaches of the federal Constitution. He said, "The legislators who caused the problem would get themselves seats at the convention and would be in a position to control the outcome of the convention." Federalist Number 49. Former U.S. Supreme Court Justice Arthur Goldberg said in his September 14, 1986 op-ed in the Miami Herald that he reminded us that at the convention of 1787, the delegates ignored their instructions from the Continental Congress, and instead of proposing amendments to the Articles of Confederation, wrote a new constitution. And he warns that any attempt at limiting the agenda would almost certainly be unenforceable. Former U.S. Supreme Court Chief Justice Warren Burger wrote in his June 1988 letter to Phyllis Schlafly, quote, "There is no effective way to limit or muzzle the actions of a constitutional convention. After a convention is convened, it will be too late to stop the convention if we don't like its agenda. A new convention could plunge our nation into constitutional confusion and confrontation at every turn." Yet, false friends dismiss these warnings from the father of our Constitution, James Madison, and two former U.S. Supreme Court justices as fear-mongering. Are there violent partisans, individuals of insidious views among us today?
Yes.
Yes, and they want a convention. But false friends assure us that only good, moral people will be delegates. Let's look at that claim. There are three ways to select delegates to a convention. Congress. Does anyone here trust Congress to appoint only good, moral people as delegates? No one. State legislatures. Does anyone here trust your state legislature to appoint only good, moral people as delegates? The people. Does anyone here, what if the state says we're going to have delegates selected by popular election? Does anyone here trust the people to select only good, moral people as delegates? After all, we have done such a great job in electing presidents, people to Congress, and to our state governments. This is the most corrupt period in our history. Lying, oath-breaking, baby-killing, parasitism are everywhere. And Americans have been so dumbed down they will fall for anything and anybody. This is no time for a convention. What did our framers say the states are supposed to do when the feds usurp power? They never said, when the feds disobey the Constitution, change the Constitution. They never said, file a lawsuit and let federal judges decide. Our framers were manly men. They advised two remedies for federal usurpations. The first is elect faithful representatives. At the Virginia Ratifying Convention on June the 20th, 1788, James Madison said, "Our Constitution depends on the people having the virtue and intelligence to select men of virtue and wisdom to office." In Federalist Number 44, Madison said, "When Congress usurps powers and the executive and judiciary branches go along with it, a remedy must be obtained from the people who can, by the election of more faithful representatives, annul the acts of the usurpers." But we keep electing politicians who know nothing about our Constitution. We must start vetting candidates for office. Learn the Constitution yourself. For God's sake, learn the enumerated powers. Conduct candidate forums where you grill candidates on their knowledge of the Constitution. I have friends in Texas who are doing this. Their congressman is Republican Joe Barton, who's been elected some 15 times. When he came in for his test, they said, "Now, Congressman, do you know the Constitution?" "Well, yes, I think I know it pretty well. I've been in Congress, 28 years. Yeah, I know it pretty well." "Well, Mr. Congressman, how many articles does our Constitution have?" He said, 5. "It has 7. "Mr. Congressman, how many amendments does our Constitution have?" "At least 20. We have 27. Shame on his constituents. They have elected this man to Congress, to the U.S. Congress, 15 times. We don't know the Constitution, so we elect dummies who don't know it." The second remedy our framers advised is resistance. They said the federal government is our creature and must obey our will as enshrined in this Constitution. Alexander Hamilton said in Federalist Number 28 at the last 5 paragraphs, and I'm condensing, "If the representatives of the people betray their constituents, there is no recourse left but in the exertion of that original right of self-defense which is paramount to all positive forms of government, and which, against the usurpations of the national rulers, may be exerted by the state governments, which will afford complete security against invasions of the public liberty by the national authority." Did Hamilton say, "There is no recourse left but change the Constitution"? Of course not. Hamilton was a manly man. Hamilton says in Federalist Number 33 at the 5th paragraph, "If the federal government should overpass the just bounds of its authority and make a tyrannical use of its powers, the people, whose creature it is, must appeal to the standard they have formed and take such measures to redress the injury done to the Constitution as the exigency may suggest and prudence justify." Did you hear that? When the federal government usurps power, we are the judge as to whether there is a violation, and we decide what we are going to do about it. Thomas Jefferson said in his draft of the Kentucky Resolutions of 1798, under the 8th resolution, "Where powers are assumed which have not been delegated, a nullification of the act is the rightful remedy, that every state has a natural right in cases not within the compact, to nullify of their own authority all assumptions of power by others within their limits, that without this right they would be under the dominion absolute and unlimited of whosoever might exercise this right of judgment for them. James Madison commented on this in his notes on nullification written 1834, quote, "The right of nullification meant by Mr. Jefferson is the natural right which all admit to be a remedy against insupportable oppression," end quote. In Madison's report of 1800 on the Virginia resolutions, he said under his discussion of the third resolution, and I'm condensing, "The states, in their sovereign capacity, are the parties to the constitutional compact, and are thus the final authority on whether the federal government has violated the Constitution. There can be no tribunal above the authority of the states to decide whether the compact made by them has been violated by the federal government. That if, when the federal government usurps power, the states don't stop the usurpation and thereby preserve the Constitution, there would be no relief from usurped power. This would subvert the rights of the people as well as betray the fundamental principle of our founding. That when the federal government acts outside the Constitution by usurping powers, then the sovereign states, who are the parties to the Constitution, must appeal to that original natural right of self-defense. That the judicial branch is as likely to usurp as are the other two branches. Thus, the sovereign states have as much right to judge the usurpations of the judicial branch as they do the legislative and executive branches. That all three branches of the federal government obtain their delegated powers from the Constitution, and they may not annul the authority of the states. And if the judicial branch connives with other branches in usurping powers, our Constitution will be destroyed. States can refuse to implement the federal government's lawless usurpations, and as a last resort, states must defend themselves from the federal government. That's why the people are armed. Madison does not say that when the federal government seizes powers not on the list, we should change the Constitution. He was a manly man and used words like refuse, oppose, thwart, and impede. So Jefferson, Hamilton, and Madison tell us, when the feds order the states to do things which aren't on the list, the proper response from state governments is no. The Declaration of Independence says at the seventh paragraph that the colonials opposed with manly firmness the king's invasions on the rights of the people. What we need in this country is some of that manly firmness, and we are finally getting it. The 10th Amendment Center reports that 200 bills have been filed this year in state legislatures to nullify unconstitutional acts of the federal government. Here are some. To allow terminally ill people access to experimental drugs and medical treatments, despite FDA rules. Drugs and medical treatments, they're not on the list. deny resources and assistance to the National Security Agency. Spying on us is not on the list, and the Fourth Amendment didn't stop them from spying on us. Nullify federal bans on growing hemp and marijuana. Agriculture and drugs, not on the list. An Indiana legislator filed a bill to nullify all EPA regulations. Environmental protection, not on the list. That is a power retained by the states or the people. Brave citizens have also started to find their spines. Rosa Parks and Martin Luther King showed us some spine 50 years ago when they nullified the state and local Jim Crow laws by refusing to obey those unconstitutional laws. Recently in Connecticut, citizens refused to obey an unconstitutional state law which pretends to require them to register their firearms. Article 1, Section 15 of the Connecticut Constitution says, quote, "Every citizen has a right to bear arms in defense of himself and the state," period, end quote. If you are a citizen, you have the right to bear arms. That's all you need in Connecticut. So the Connecticut statute, making it a felony to possess guns which are not registered, is unconstitutional as in violation of Article 1, Section 15 of the state constitution. And the people, as the creators of the state government, are the ones to ultimately decide. Disarming the American people. If Congress by law, or the President by executive order, or the BATF by rule, or the Supreme Court by opinion, or the federal government by treaty orders the people to turn in our arms, we must not comply. The Constitution doesn't authorize the federal government to disarm us. Gun control is not on the list. So the states and the people must nullify such law or order or rule or opinion or treaty by refusing to obey. All nullification requires is a spine. And Rosa Parks and Martin Luther King showed us what spine looks like. You say no more. Yet, nullification, a remedy our framers actually advised when the feds usurp power, is under constant attack from false friends who dishonestly claim our framers opposed it. Why do false friends tell lies about nullification? Because they want you to believe that an Article 5 convention is the only way out. False friends have been indoctrinated with authoritarianism and they can't think. They don't tell the truth, or they are ignorantly repeating the prevailing authoritarian dogma. So it's up to us. We must man up, throw off the indoctrination, learn our founding documents. See how short they are? Educate our countrymen, trust no one to tell you the truth, and repudiate cowardice as the proper response to evil. Do not let the light we lit in 1776 and 1787 be put out by men of insidious views who scheme to get rid of our Constitution and replace it with a new Constitution crafted in the pits of hell. Thank you.